This is the October 20th meeting of the Post-Conviction Standards Work Group. And I will pull up the working document and pick up where we left off last time. I think y'all should be able to see that. Does that look right in terms of where we were? I'll see that okay?
Yeah, I had something to add to the like pleading of the petition. I think we had talked about that a little bit, and we're gonna
like the asserting legal claims part?
Yes, I think so.
Great.
Yeah, like what all we need to plead. So there's, let's see, what is this? Like the fourth sub-bullet point, the successive. So we talked about the like successive petition and or untimely and needing to plead that it falls within the escape clause. And we had talked about Palmer as well. It was like if it could have been raised in a direct appeal. And there are some exceptions to the Palmer bar that are listed out in North v. Cup, which are, I can like read those or I can just give you the citation.
Yeah, you can just give me the citation.
Sure. So it's 254 Oregon 451, and it's at 456 to 57. And it lists like, yeah, it lists four exceptions to the Palmer bar. We, my office, are not totally sure. I think the case law is not totally clear on whether those have to be pleaded in the petition. But it would definitely be best practice. And it seems like the court hasn't directly addressed this issue, but it seems like the reasoning for why like the statute of limitations escape clause has to be pleaded would apply equally well to this. So it seems like it probably does.
Great. Thank you.
Yeah, I agree with that, Meg. I have a case under submission right now where that was the argument is that particularly for the ineffective assistance or inadequate assistance of counsel, that it doesn't have to be pleaded and proven, that's not said anywhere. But I agree that we should be pointing out in the claims, like just basically, I think saying make sure we cover the Palmer ball or make sure you cover the Palmer bars with the citation. I think that would be the direction to counsel in this in these in this guidance here.
Okay.
Oh, the other piece that we wanted to add into that was this is a suggestion from like the appellate side, which is when they're pleading a remedy to include the like whatever remedies are proper and just and cite the statute, to include that with whatever other specific remedies are being pled. Otherwise, we're like very limited on appeal of what we can argue. And that is like just what, it's just the statutory language. So it's not anything too fancy.
Like that?
Yeah. Okay. I think that's all I have.
When I dropped off last time and y'all jumped on to habeas with Jordan, he messaged me and said they wanted to remind you to ask about, oh, maybe this is for, it might have been this was Ginger's thing, so I'll let her in and then ask. Hi, Ginger.
Hi, sorry about that.
No problem. I was just asking about something I think you asked Jordan to tell me last time, Ginger, about
Oh, yeah.
asking for more than 30 minutes to litigate claims.
Yep.
Tell me about it.
Sure. So normally a post-conviction trial is set for 30 minutes unless you ask for more time. So I just wanted a reminder in there that if people needed more time than 30 minutes, then they should ask that there'll be like a status conference when you set the hearing. So they should make sure and ask for additional time if they're going to need it. So I don't know, maybe that's like a practice note.
Well, I don't know if we include this here, but I've noticed certainly recently, judge not being at all familiar with filings, very lengthy. So even like I said, a 3 hour, and I'm like, this will be enough time to argue, having read, and the judge wasn't familiar with anything, and it you know, and it's so I think definitely asking for more than 30 minutes and expecting that you're putting on you may have filed a long trial memo, a long motion. You can't expect the judge to be familiar with any of it.
I'm sorry, just to make sure I'm understanding, the default is that the entire proceeding where you're arguing and calling witnesses and everything would be 30 minutes unless you've identified in advance that won't be the case?
That's correct.
Yep.
Wow. That's not a lot of time.
Well, it's because a lot of the testimony is just done through declaration.
Mm-hmm.
And then the Department of Justice, for the most part, will rely on, like if you're going to stand on your briefing, then a lot of times the Department of Justice will stand on their briefing as well, and there won't be any argument. I'm not upset about the half an hour because there's certainly a lot of post-conviction claims or post-conviction cases where half an hour is sufficient, but
yeah. Okay.
Yeah, you just got to know your case at that last status hearing.
Okay. Well, this is where I don't know if we were actually at the bottom, but this is where we ended 2 weeks ago in terms of what we put in. I don't know. I should have gone back and watched the end of the last recording, but I didn't.
For the petition pre-appeal, I wouldn't say the PCR court is stripped of jurisdiction. I would say lacks jurisdiction.
Gotcha. That's not after trial necessarily. That's just a place we put it.
Right.
I think maybe we were just going through these sub-bullets and starting to flesh them out. And so maybe, I don't know if there's flesh to be added to the objection section, other than you have to look at the other side's exhibits and just figure out what to object to. But I think it's possible we were there unless there was more to be said about filing exhibits.
Mm. I don't know that. I would be interested to know what Ed and Meg say. In my declarations, in addition to saying this is what I would have testified at the petitioner's trial, I also say this testimony is what I would testify to, like at this post-conviction trial as well. Like this, I should look at a declaration. Hold on.
I haven't had that come up yet, but I kind of operate from the assumption that the state may call for cross-examination,
Yeah.
a declarant, well, they haven't, I always operate from the presumption that lean towards the side of anybody they're going to provide a declaration for, I'm gonna put on for testimony, although they've been using declarations for people who aren't even in the jurisdiction lately, so raises some interesting issues.
So this is the last paragraph of my declarations. I say, if I were called to testify at the hearing in this post-conviction case, my testimony would be the same as my statements herein and explanations outlined in my expert report. Again, maybe that's just a practice tip and not something that has to be done, or
Yeah, I haven't seen that ever be an issue, but it doesn't seem like a bad thing to have in there just in case.
Okay.
I think the objections to the exhibits should be in writing to the, and then you'll have the chance to respond to their objections in writing as well, because you'll get those 10 days before, or actually 20 days before the hearing. So in my response to the trial memo, we always do response to the objections and then objections of our own.
Sorry, all of
Some
that is this just what you just said there, Ginger? All of the objections are part of the trial memo? Is that a subset of trial memo, or is that different?
I don't know that that's the important piece. I think I've seen it where people respond to the objections in their response to the defendant's trial memo. And I've seen a separate response to objections. I don't know that the important piece is where it is. I think the important piece is, I think it should be in writing.
Yeah. Sorry, I just didn't know if some of what we're doing is actually a subset of trial memo always, or it sounds like it's however you want to structure it.
Yeah, I'm sorry. I got ahead of myself. That it goes in the response to the defendant's trial memo.
Response to statements.
Meg, do you think that it matters where it is for appeal?
I don't think so. I think as long as it's in writing, I don't think it matters. Yeah, I've seen it both ways.
I think sometimes the scheduling orders give some specifics, and sometimes there isn't a scheduling order on that point. So I think we should just make some reference to, like, in compliance with scheduling orders, or to look at the scheduling orders, because it might have more detail. It might not be an order at all.
And I guess as a practice tip, if you fail to make the objection in writing, you should still object at the hearing.
Yeah, you can definitely object at the hearing too. I don't think, yeah, that's not best practice, but that is still an option.
Anything else about objections other than that they should be in writing, or otherwise it's kind of just straightforward?
When we're talking about the objections in this section, are we talking about our objections to their exhibits or their objections to our exhibits?
I think I was assuming the former, and then we can flesh out response to state's objections
Okay.
in the
Okay,
response to
perfect.
trial memo section.
Mm-hmm.
Do we move on to trial memo, or is it something else make sense before that?
I think that makes sense.
Yeah.
The objections is in a weird place because you're not gonna get their exhibits until after they file their trial memo. But it does make sense that it's up by filing exhibits as well.
I mean, right now, all we're saying about them is that they should be in writing, really. And
Yeah.
so we probably could move it. But when you do objections to exhibits, they would go in your response to their trial memo?
Yeah,
well?
at that same time. When we object, we file the objections at the same time as our response to the defendant's trial memo or contained within our response.
But then, wait, sorry, are the trial memos not filed at the same time necessarily?
They're not.
Oh, okay. Okay. That was the piece I was missing.
Yeah.
I was going to say, how could you respond to their objections?
So maybe do petitioner's trial memo right here, where your cursor is.
Yeah. So you respond to states objections, and then your objections to states exhibits, and then go back to in the trial memo. I assume there's some things, regardless of what's in the scheduling order, that you want in the trial memo.
I mean, that's a tough one. It's the coalescence of the facts and the law for your claims.
Mm-hmm.
So is the trial memo a proposed finding of facts and conclusions of law? Is that what purpose it serves?
Entirely different pleading that we are sometimes asked to file. So the trial memo is, I mean, this is how I explain it to my clients. The petition is a skeleton of your claims, and then the trial memo fleshes out both the facts and the law for each claim. And so it's a very comprehensive document.
Okay.
Yeah,
So
it's much more like an appellate brief
than
than other trial documents usually are.
I would say mine, it's a hybrid between motion for summary judgment and appellate brief. Sometimes just basically like a motion for summary judgment, but yeah, they can definitely look a lot like appellate brief, especially when you're having kind of novel legal issues.
And it's really where like the bulk of the argument for the whole case goes, which is why the hearings tend to be shorter, because these tend to be like the real meat of the case.
I mean, do you think we should break it down into the different sections of the trial memo? Or
I'm not aware of any formal rules. So I mean, absent a formal rule, I don't know that we have direction for other practitioners. But obviously, it's a practice. You're probably gonna have a short hearing. It's gonna be heavy. It's not like any other trial situation. It's going to be heavy. It's much more like an appeal, that it's heavy on what you're briefing as opposed to what happens in court.
Yeah, this is another place. Sorry. Go ahead, Colin.
Go ahead, Mike.
Oh, okay. This is another place where it might be helpful to note that, like, if you don't make a legal argument about a claim, the court is almost certainly going to deny that claim. It's not quite the same as like the evidence requirement, but it works the same way of like you're basically forfeiting the claim.
Even you're saying even if you made it in your petition, if you don't then
Yeah.
support it in the trial memo, it's like you're waiving it.
That seems to be how it's treated. Yeah.
Okay. So I assume what you were saying earlier, Ginger, was I assume you have your way you structure it. You have like a standard of review and you have the facts section for that claim and a legal section for that claim. But then Ed was saying, well, we don't have to. So everybody, theoretically, you could structure it any way you wanted, and there's no requirement that any of those particular things be there. It's just that's what most people would do, is have certain sections. Is that my understanding right? The conversation? Okay.
Yeah, I think that's right. So maybe just what Meg said, just that you basically must brief every claim that you want to litigate.
Is there a rule about, I guess we've talked before about how you can present your facts live or in declaration. Is it such that if you don't say in the trial memo what you expect someone to say factually, that you can't try to support it at the trial? Or what is anything to be said about the way the facts come into the trial memo versus the way they might come in or might come in differently at the trial itself?
In my experience, you don't, if you're going to call somebody at the trial, you don't need to talk about their anticipated testimony. I don't know, Meg, maybe that's bad practice, so.
You can talk about you can sort of say like, petitioner anticipates so-and-so will testify consistently with whatever. I do see that, but I don't think there's any requirement that you have to. Yeah, there isn't a requirement that you have to. I think that's probably also true, if you didn't make a legal argument in your trial memo and instead just made it at the hearing, that wouldn't have the same effect of waiving the claim. Yeah, that definitely not a best practice, but could do that.
But if you're making sorry, just to clarify, if you want to make your legal arguments about facts that have not yet come out, I guess to your point about waiver, like, is it important to make the legal part of an argument somehow, even if the hearing hasn't, if you're anticipating live testimony and the facts aren't in yet? Like, how do you deal with those claims? Or maybe this happens rarely and basically everybody always just pleads everything, and so I'm overcomplicating. I'm just trying to follow the structure.
I just think that more often than not, you say so-and-so is expected to testify.
Yeah.
And then you go forward with your legal argument. People should not forego a legal argument because somebody's going to testify in writing.
Yeah.
Okay.
And yeah, because it's not like a criminal procedure where you're limited in your discovery tools. We talked about some victim limitations, but generally speaking, you should know, any witness you're calling, you should know exactly what they're going to testify to before trial. So I don't know of any reason why you shouldn't be able to do that. I mean, if you're getting into someone that again, a victim, I don't know, you could assume they're going to testify consistently. Even if it's your client's trial counsel, you should take their deposition if you don't know what they're going to say and have an idea. So I just kind of would want, I think it should be briefed, and also I think people should have an understanding. You should be able to, in your trial memo, say what the evidence is going to be, notwithstanding how witnesses sometimes have surprises in their testimony.
Yeah, I agree with that.
Now that I understand, is there anything that we should put in here standards wise about any of that, or maybe that just complicates matters. We should just be saying this is where you need to flesh out the facts in the law for each claim to the extent possible.
Briefing every argument, I think is good. And I don't, again, for me, I can't really think of what the basis for me to do a summary judgment in federal court or something was, but it's just kind of that understanding is I've got to incorporate all this. I've got to reference all my evidence. I've got to make all these arguments and have all this go ahead. I mean, it was just, to me, it was just kind of knowing going into the proceeding what I had to do.
I mean, I think that we should assume for the purposes of the standards that, somebody doing a post-conviction will understand the legal standards for post-conviction. So I don't think we need to flesh that out in this section. I think that people just need to understand that every claim needs to be briefed.
Yeah.
Okay.
One thing that this discussion reminded me is there are times when the claim will be ineffective assistance of counsel for failing to do something at trial, do something. And then at trial, the state will call trial counsel as a witness, and trial counsel will come up with a reason why, whatever strategic reason they had for making this decision that was not, that might not be apparent from the record at all, of like that there was a strategic decision or what it would have been. And kind of the alternative way of arguing that claim is like rather than just like failed to do something, failed to like execute the strategy effectively. So like they're saying what their strategy was, but if you can't identify that strategy from the record, it probably isn't one that they did very effectively. And so that's kind of an alternative way of getting at it. And we've had situations where the Court of Appeals has said that like failing to execute a strategy effectively and failing to do this other thing are not the same, are not encompassed in one claim, that those are two separate claims. They have to be pleaded separately in the petition. So that is, I don't know, maybe that goes in the petition. I think that does go in the petition section of like pleading alternative theories. One of those being like failed to reasonably execute. The other way you can deal with that is at trial, just saying to the court that you want to kind of amend your petition to incorporate this other theory. And that should be permitted. But it's important to like actually identify that this is a separate theory and argue it that way. And deal with the fact that you didn't plead it in your petition if you didn't.
So that last part seems like it's something that's a trial tip is,
yeah.
if during the hearing claims possibly change, make sure to identify that for the court in the moment.
Yes, and request that the petition be treated as amended, or to like actually amend the petition, either way.
So if that's what we're saying about the trial memo, and then I think this status conference one is just a general tip. I don't know should we have a separate status conference bullet that's a sub bullet to, or is there not much more to say it?
I'm not even sure we want to say a lot of status conference, because I have some cases where we file the pleadings and we get an email, are we ready to set trial? And it just happens by email without even status conference. I agree with the substance there.
Oh,
I don't know if we basically just refer to it as trial setting as opposed to even status conference.
I think that sounds good.
was there more to say about response to the trial memo?
The only thing that I would add is when you're responding to the state's objections, you have time to cure hearsay objections. Or I should say, you have time to cure any objection. You know, so you can, if it's, we get a lot of hearsay objections when we're relying on police reports for something other than what trial counsel had. So if you get a hearsay objection, then you can get the declarant, get a declaration from the declarant and submit that. I think you can, I've submitted them even up to the date of the hearing. So I think that people should be aware that they can cure hearsay objections. Or I shouldn't say just hearsay objections, that they can cure objections.
I've seen courts allow that to submit something even after trial.
Is that something where
be afraid?
Yeah.
If you have assuming there's like a deadline when you need to file your response to the trial memo, and you don't know if you're going to be able to cure, do you have to say, hold off on ruling on this objection, judge, to avoid having to reopen it? Or is it okay if the judge says, I grant their objection because there's hearsay and you haven't provided me with a way around it, and then 2 weeks later you come back and say, I got this declaration, so I want to go back. Is that okay, or do you need to have kind of telegraphed in advance that you might do that?
So how it happens is at trial, the first thing that's done, or close to the first thing that's done, is you offer your exhibits. And so the judge, more often than not, in your just standard post-conviction hearing, the judge isn't going to make a ruling on the objection. So you have time before the trial starts to argue your objections. And like Meg was saying, you can even say, I am anticipating being able to cure this hearsay objection. Can you give me 10 days to cure it? And the court will say yes or no. Like 10 days after the hearing.
Mm-hmm.
Again, not best practices, but the judge is going to take at least 60 days for most post-conviction cases, likely longer than that. So a lot of times you'll be granted leeway to cure an objection if you can.
This might have been something you all discussed before I started coming to these, but are there any evidentiary rules that are, that are different? I mean, I know, like in Louisiana, for example, some hearsay rules are relaxed in a post-conviction proceeding. It sounds like that's not necessarily the case here at a post-conviction trial.
I think the evidence code applies with the exception of the statute that says, evidence can be by affidavit, deposition, what have you. But otherwise, I think the evidence code applies in full force.
Yeah, and particularly because the evidence, whatever you're seeking to admit, needed to have been admissible at trial for most stuff. And so it needs to adhere, to, I guess, the criminal rules of evidence, if such a distinction exists.
Anything else to say about either response to state's objections or the objections to the state's exhibits.
Do you think that we should put in that the response is optional?
This is response to the trial memo or the response to the state's objections?
Response to the trial memo.
Or do we even want to refer to the UTCR? Because I mean, it could change. It sets out timing and the response. But I don't know if we want to refer to the UTCR in the event they made some change on that.
Yeah, I don't know.
That seems reasonable to put in the UTCR. There are very few responses filed, so I don't know that we need to emphasize that it's optional. It would be helpful to have
More? That's
more.
what Mike, I mean, we always file them, so I didn't know if that's what,
Yeah.
I shouldn't say always, more often than not we do. I didn't know that if that was standard or not.
I mean, yeah, obviously there are cases where it makes sense not to file a response. There are
Yeah.
good reasons for that. That's totally fair. But yeah, I don't know. We need
So
it.
people just not filing a lot of responses?
Yeah, it's pretty unusual.
Well, that's,
Does the state have also the ability to respond to yours?
No.
Oh.
No, it's 10 days before. It's 24.050 is the UTCR, and it gives, our trial memo is 30 days before trial. Theirs is 20, and then the response is 10. I mean, but again, the court would receive written materials at the trial.
oh, I don't know about that. I don't know if they would receive a response. I would not bank on that.
No, not a response, but a motion, a supplemental authority motion, that kind of thing.
Yeah.
I mean, if not, what I do, I just read the whole thing into the record. If
Exactly.
the court wouldn't, so.
Other than objections, anything else to be said about the response?
I mean, just that you should respond to the state's arguments, but hopefully that's clear in the title.
Yeah.
I don't know.
Okay. Well, should we move on to trial?
Sure. So I have new information for this, your client appearing.
Oh yeah.
So I just had a situation last week where my client didn't appear. We had it in place. We had a guardian ad litem in place, so I did not believe that my client needed to appear. The state objected to moving forward without my client, even with a waiver, because the way they read the statute is that the petitioner has to be there. You cannot waive their appearance. If they're not there, then the state will move to dismiss for failure to prosecute.
Yeah.
And pursuant to the statutes, like if they just don't show up, then the court should reset if the judge hasn't previously ordered their appearance. So what the court did in my case was, because my client wasn't previously ordered to appear, they then issued an order for him to appear. And then if he doesn't appear, then the state will move to dismiss the case. So I don't know that what we had written with regard to the waiver of a client's appearance is.
That is not, so the Court of Appeals does not agree. That was,
Okay.
we presented that as the argument that that's how it should go.
Is that-
that a client was required to be there or to have personally waived the right. And they rejected that and
Okay.
said that a lawyer can waive on their behalf.
Okay.
Um,
That's
but that's interesting.
it is very interesting. Okay, can waive. So maybe we just leave it as is, how we have it written, since that's what the Court of Appeals has said.
And
I think that's right.
Because there's a statute about essentially remote appearances, do we want to reference it? I know, Ginger, you raised in the first round of standards not agreeing to telephonic, and I hadn't had the issue come up, and I had it come up about a month ago that video wasn't working. So they brought my client in by phone, and he informs me about a third of the way in, it dropped. He wasn't even on, and nobody even knew it. So
And I mean, that happens all the time. Not all the time, but it certainly happens. Well, I mean, so it says client should object to any attempt to limit client to solely telephonic appearance unless client directs otherwise. Does that pick up your concern?
I don't know. I mean, I found this when I was trying to, I started doing PCRs kind of coming out of COVID. And the only reason I sort of knew there was a statute is because I was trying to make sure a client was present in court, someone from the state hospital. So I don't know if we want to note that there is, 138.622, it authorizes, I'm sure at a time that it wasn't common, that the client can be remote, but that they have to have simultaneous communication and opportunity to, talk with counsel when in house. I don't know if we want to have that somewhere to direct practitioners to it.
622, 138622. Is that what you mean?
Yes.
Yeah, so that's in there already.
I'm not even sure. I mean, why would a client direct us to telephonic, and why would we want to do that at client's direction? But they could be in an infirmary or something and not want to leave.
I think transportation can sometimes be.
Yeah, if they're out of custody.
Oh, that's true. Yep.
And they don't have access to a computer, or where the video is not working at the institution and the client wants to move forward to keep his case moving forward. And if it's a purely a legal issue, then I'm fine with that, but I understand what you're saying, Ed, is that we don't know if the call the call drops.
Well, and even the amount of pushback you'd get during a telephonic to to follow through on 138.622. Oh, hey, we need to privately consult, and we have that right. I mean, it's not significantly better in video, but at least it's going to be like there, visible in front of everyone. If it is telephonic, I don't know I don't know. Have you been able to do that, Ginger?
I have. Well, I shouldn't. I mean, to the best of my knowledge, I have, because you are still on the video and you see everybody else on the video and you see your client's telephone number. And then if you ask to confer confidentially with your client, everybody else gets put in a breakout room and you see that. So in terms of the confidentiality piece of it, I think it's the same if your client's on the phone versus on the video. If everybody was on the phone, then you would have the problem because you wouldn't be able to see who's in a breakout room and who's not. So it sounds like for you, Ed, you don't want in any way to promote that the telephone is okay.
But I do have clients, in the infirmary it may not be easy. And like you said, out of custodies may want to go that way. So I think those are really good points.
Yeah, and I mean, if your client is telling you, I just want to have this over the phone, it's probably not their like constitutional right to make that decision, but I think it's okay for them to decide how they want to appear, especially if we mandate that they appear via video. They can't do that, and then their case gets dismissed because they've been ordered to appear.
We are gonna, at least in the other performance standards groups, we've been including some introductory language that clarifies that sometimes, even though we call something a best practice, it won't apply in every case. And that there are even times when some best practices might be contradictory with other best practices. Just, some things are going to be black letter, and then there are other things that you're going to do most of the time, but given the facts of your case, you might pivot. So at the moment, we have this telephonic one as object to limiting the client to telephonic unless the client directs otherwise, and that seems to capture what the conversation has been, that like almost all the time you don't want to do it, but there will be exceptions.
I think so, but I don't know. Meg, what do you think?
I think this seems fine, but yeah, I feel like you guys are the ones that are working with the clients more and have a better sense of like what works for this practically.
We can always come back to this as well if your thoughts evolve.
The thing that I want to look into is whether or not they can waive their appearance. That's the big thing that I want to look into before we sign off on this. I'm fine with the best practice as is.
Yeah, I was looking back at that case that I had, and the Court of Appeals affirmed that opinion back.
Okay.
It was a couple of years ago. But it was a situation where, so yeah, who knows what their reasoning was exactly, and maybe it'll come back up and be different. But it was a situation where they didn't know where the client was. Client was supposed to be there, didn't know where he was. And counsel says, like, tried to let him know. I'm not sure if he actually knows that there's a hearing today. I'm fine with just continuing as is without him. And so that was.
So there wasn't even a client waiver.
Not like personally from the client. It was like counsel on the client's behalf.
Well,
which I mean, it's a little tricky in the like appellate situation because you have like an invited error from petitioner's counsel. Because counsel asked to proceed without the client. So that makes it tricky on appeal, which doesn't mean that that's, necessarily what the rule would be without those annoying procedural issues.
Yeah.
So,
well, yeah, like I said, the Department of Justice was not willing to move forward because they didn't want a situation where if we lost at trial, it went up to appeal and then the Court of Appeals sent it back down because the client wasn't there.
Okay. Yeah.
So.
And you said you even had a guardian ad litem there.
Yes.
Yeah, that's surprising.
Can I ask about that? We actually had a call with a question that none of us here knew the answer to about having guardian ad litems in post-conviction. And one of the threshold questions was that the client had decompensated over the course. And there was a question about whether apparently there's an ethics opinion in the, I want to say, dependency context that says that the lawyer cannot initiate guardian ad litem request on behalf of the client. And the lawyer was asking us, said, well, what do I do? I think he needs a guardian ad litem. Am I allowed to ask for that? Okay, did
No,
you say
you're not allowed to
okay.
do it without the consent of your client. So I reached out to understand my obligations as well. And it's considered an adverse proceeding against your client if your client is not requesting it.
Mm-hmm.
And so hopefully the person will have a family member or that will step in.
Yeah.
It becomes complicated because this is like a broader issue because OPDC will not appoint somebody to help the family with the guardian ad litem. So the family then has to finance that on their own. So it gets complicated, but my understanding, just to reiterate, is that it's adverse action against your client if they don't want it. So I've had both. I've had a situation where the client requested it, and I've had a situation where the client had decompensated.
And in the decompensated context, well, I guess if you can find someone else to make a request, then but are you allowed to suggest to another person that
this is an ongoing case. I don't want to talk too much about it. I'll just say that I could not make the request for guardian ad litem.
Yeah.
And, the situation becomes really sad because how do you move forward with really good claims in that situation?
Yeah.
So, yeah, it's terrible.
Well, this might be a reasonable place to stop for today, so you guys have a few minutes before habeas kicks up. But I think we made good progress today. So thank you all. And
I have a call at 1, so I'll try and jump on the habeas one when I'm done.
All right.
Thanks, everybody.
Thank you. See you in a couple weeks.
Okay, bye.